Hello and welcome to TaxPundit. The case under discussion is DCIT versus Bazigar Trading Private Limited, Mumbai Tribunal, pronounced on 26 May 2026. Let's dive into the facts of this case. The Assessee, Bazigar Trading Private Limited, filed its return for assessment year 2011-12. During scrutiny, the assessing officer noticed a substantial jump in unsecured loans from 9 crores 95 lakhs 38,245 rupees to 15 crores 92 lakhs 3,936 rupees. The AO made additions under Section 68 for unproved loans of 5 crores 61 lakhs 65,591 rupees, plus an addition for sundry creditors of 4 crores 97 lakhs 83,000 rupees, and a proportionate interest disallowance of 10 lakhs 92,239 rupees. Additionally, a disallowance under Section 14 was made. In the first appellate stage, the Commissioner of Income Tax, Appeals, granted substantial relief to the assessee by deleting most of the additions. This led to cross appeals before the Income Tax Appellate Tribunal. The Revenue challenged the deletion of the Section 68 additions, the consequential interest disallowance, and the restriction of the disallowance under Section 14A to the exempt income actually earned. On the other hand, the assessee contested the CIT appeals decision to sustain an addition of 35 lakh rupees for a loan from Messrs. Bengal Exim Script Private Limited. The tribunal first addressed the onus under Section 68. It reaffirmed that the initial burden lies on the assessee to prove the identity of the creditors, their creditworthiness, and the genuineness of the transactions. The assessee had submitted basic loan details during assessment, but the AO did not specifically call for confirmations, which the tribunal noted as a violation of natural justice. During the appellate proceedings, the assessee filed additional evidence under Rule 46A, including confirmations, PAN details, bank statements, and ITR acknowledgements of 8 loan creditors. The CIT then called for a remand report, and the AO issued notices under Section 133(6) to verify the claims. The assessing officer questioned the creditworthiness of 3 lenders, Messrs. Straight Curve Ideas Private Limited, Messrs. MKJ Entertainment Limited, and Messrs. Conreach Security Solutions Private Limited, based on their low returned income. However, no adverse finding was raised against other lenders like Muniraj Commercial Private Limited and AB Court Limited. The ITAT held that low income alone cannot be a standalone ground to reject creditworthiness when financial statements and bank records substantiate the transactions. Crucially, the loans were advanced through banking channels, were subsequently repaid, and interest was paid after deducting TDS. This established the genuineness of the transactions. The Revenue failed to rebut the documentary evidence, so the tribunal upheld the deletion of the Rs 5 crore 61 lakh 65,591 addition. Moving to the interest disallowance, the Revenue's ground for deletion of the interest addition of Rs 10 lakh 92,239 was dismissed as consequential. The assessing officer had computed this disallowance proportionately based on the unproved loans. However, since all loans except the one from Bengal Exim were held to be genuine, no interest disallowance was warranted. Notably, no interest was paid to Bengal Exim, the only lender for which the addition was initially sustained. Therefore, the CIT correctly deleted this addition, and the ITAT affirmed that decision. Regarding the disallowance under Section 14A, the CIT had restricted it to the exempt income actually earned. The Revenue argued that the disallowance should be computed as per Rule 8D without any such cap. The ITAT referred to the settled legal position, including CBDT Circular No. 5/2014, which clearly states that disallowance cannot exceed exempt income. The tribunal also addressed the explanation inserted by the Finance Act 2022, which sought to clarify the legislative intent. However, the ITAT held that this explanation is prospective in operation and therefore inapplicable to the assessment year 2011-12. Thus, the CIT appeal's deletion was upheld, as the revenue brought no new evidence. Now let's look at the assessee's cross-appeal. The assessee contested the CIT appeal's decision to sustain an addition of 35 lakh rupees for a loan from Messrs. Bengal Exim Script Private Limited. The ITAT noted that the assessee had provided all documents within its power, including confirmations, pen, and bank statements. The creditor was under liquidation, which limited the assessee's ability to secure further evidence. Importantly, the revenue made no adverse finding about the genuineness of the transaction during the remand proceedings. The tribunal firmly held that suspicion cannot replace evidence. Since the assessee had discharged its onus, the addition was deleted. In conclusion, the Income Tax Appellate Tribunal dismissed the revenue's appeals and allowed the assessee's cross-appeal in full. The order reinforces the principle that the onus under Section 68 shifts to the revenue once the assessee provides prima facie evidence of identity, creditworthiness, and genuineness. Low income of creditors is not a standalone ground to reject creditworthiness. For Section 14A, the pre-2022 position that disallowance cannot exceed exempt income remains valid for earlier years. The ITAT also highlighted the importance of proper inquiry by the AO and adherence to natural justice. While the High Court may review this matter if appealed, the ITAT's reasoning aligns with established jurisprudence. A common question is, what does this order mean for taxpayers facing Section 68 additions? The ITAT has clarified that taxpayers can discharge their onus by submitting confirmations, bank statements, and ITRs of the creditors. The assessing officer cannot rely solely on low income of the creditors to reject creditworthiness. Evidence through banking channels is critical. Another important question: can the revenue apply the post-2022 explanation to Section 14A for older assessment years? The ITAT has clearly held that the explanation inserted by the Finance Act 2022 is prospective. For the assessment year 2011-12, the disallowance under Section 14A cannot exceed the exempt income actually earned. What can the revenue do if it disagrees with the ITAT order? The revenue has the option to file an appeal before the jurisdictional High Court, but only on a substantial question of law. This is a standard remedy available under the Income Tax Act. Why did the ITAT delete the 35 lakh rupees addition even though the creditor was under liquidation? The assessee provided all available documents, including confirmations, PAN, and bank statements. The revenue failed to bring any adverse evidence during the remand. The ITAT held that the creditor's liquidation does not automatically make the loan non-genuine if the assessee has discharged its onus of proving the transaction. Thanks for watching this video. You can download the full analysis, case law, and case digest PDF from our website, taxpundit.org. Feel free to write to us or message us on WhatsApp at 932-630-6668 for any assistance. Don't forget to subscribe for more landmark updates.